Hi, everyone. Welcome to Legal 252 Civil Litigation. I'll give everyone a second to log in. I always start slow the first minute. Okay, so for this semester, I'm your professor, Cheryl Bernardo. You call me Miss Bernardo, Cheryl, professor, as long as it's one of those three. Um, we will be learning the entire process of civil litigation, right? From beginning, when a plaintiff goes to a lawyer and files their complaint, all the way up through discovery, where we're going to do research and invest in investigation to help our attorneys with their presentation at trial. And then we'll talk about what happens during trial and the aftermath of the appeals process. So we only have an hour and a half, unfortunately. We're not given an excellent time slot of 6 to 9 p.m. for a civil lit, and there is a lot to cover in this class, so I will always start right away and use the full hour and a half to make sure we get through everything. This class will consist of in-class assignments. So I'll give you guys an activity, sometimes either in a group or individually. And then there will be homework. And your final, I'll split you guys, well, depending on how many people added the class. So there's quite a few of you. We might have two different cases which I'll have two different teams, plaintiff and defense, and you guys will present your side for the class. You guys could use PowerPoint slides, or you could just talk about your legal arguments on either side. And we'll either have one big case, or maybe I'll have two cases and have four teams, right? So just letting you guys know in advance. And for the finals, you guys have to be here to present. If there's an emergency of some kind, maybe we could work it out, but you guys really have to be here for that final. Otherwise, your team will have to carry more weight. Okay. So let me go ahead and just show you guys my screen and what I normally want you guys to look at. So on Canvas, this is the home page, but I'll always want you guys to go into the modules section, right? That's where everything is. So I wanted to let you guys know that I put all of your readings in here, any videos I want you to watch, any activities. So in-class assignments will be on here, homework will be on here. I'll probably create a separate module if it's like the midterm. There will be a midterm multiple choice test on litigation terms, which are, you don't have to memorize anything in the legal field as a paralegal, just you know how to find it. But it is easier for you when you work in the field, when you know it by heart. So, and actually, I already have the terms list here. If you guys want to start looking at it around week 7 or 8, well, I'll have this multiple choice test on litigation terms. So everything is here, and I always want you guys to go directly here for anything, just because I've had students, it's kind of common, go straight to the assignments tab and try to just skip all the readings and do the best they can in the assignments tab. Right. I've had a lot of students go from like an A to a B minus or an A to a C because they didn't read the full instructions in the modules section, right? And they easily would have gotten the A if they just read the entire prompt in the module section, right? I don't put everything in the assignment box, right? All of the detailed instructions will be in the module section. So just want to let you know. And it's too late if you turned it in, right? So just want to let you know, go here first. So looks like you guys all found the Zoom lecture link here. Every Thursday, 12 to 1:30. My office hours are from, oh, that says Thursday. It should be Friday. Sorry, let me change that. It should be Friday, 4 to 6, unless I tell you in the announcements section, I move my office hours, but it will always be on Fridays from 4 to 6 o'clock. You don't have to make an appointment. You can just drop in. There's a waiting room. I only take one student at a time. And so if you're waiting there for a while, don't worry, I take everybody, even if it goes a little over 6. If there's a barrage of people, I try to get to everyone's questions. It's just that some students have a list of questions, and I might be in there with them for 20 minutes. So just hang tight while you're waiting. Syllabus is right here. So it's just, again, a link of our Zoom, our time slots, my office hours link. Oh, email me on Canvas versus my direct email address now that you guys are all registered. I'll see this inbox more so than I will any other my smccd.edu. I get a lot of administrative emails in there, so you're going to want to just supersede all of that and just go directly to the Canvas inbox because I only get student emails in the Canvas inbox. Final presentation, I just put that in there. You can be as creative as you guys want to be for the final presentation. Academic integrity, right? ChatGPT. So I'm okay if you want to use ChatGPT to help you. Like if you're driving yourself crazy and you can't find a legal citation, right? You don't know what the criminal code is for larceny or something, right? You can't find it. I'm okay if you want to ask Gemini or ChatGPT quickly what the code is in California, but I would expect you to look it up on the California legislative website to make sure it's correct, right? So I'm okay with quick searches like that, but for your critical thinking responses and your legal analysis, you guys have to come up with that on your own. Right? You can't just put the legal issue prompt into ChatGPT. You really have to compare the law, what it says in the law, to the fact pattern that I give you, and tell me, how to solve this problem. Right? Can we win this case? Is it heavily against us? Because in the real world, you can't cut and paste your client's legal issue into ChatGPT. That's a public platform. It's a violation of client attorney privilege. You get in a lot of trouble and get sued for legal malpractice, right? So you can't leak anything to the public. That's the issue with AI tools. Although we are really lucky nowadays in any legal software that you normally would use now has AI tools embedded in it, which is fine because your firm pays for that specific license. You shouldn't have to worry about client attorney breach. Computers access, so everyone needs a computer in this class. Tablets with a keyboard, so far from my experience, students have had trouble seeing a whole government website. Sometimes they can't see all the tabs if it's just a tablet. So just so you guys know, you need a computer. Otherwise, what I share my screen and show you a government website and you can't see the whole thing, it's probably because you're on a tablet. So if you don't have a computer, you only have a tablet, you could attend class with the tablet, but your homework has to be done on a computer. Otherwise, you can't actively see everything. Grading, scales of grades will be based off of in-class assignments, homework assignments, and then, of course, the bigger midterm final project. That's what it'll be graded on. I accept late work. I'm okay with that. You're allowed 3 absences since this semester long is 16 weeks or so, or 15 weeks. That's pretty lengthy. So 3 is okay. 4, I'm going to need a doctor's note. I'm going to need to know it was an emergency. I'm going to have to drop you after 4. If by chance I just missed the withdrawal period, I will have to heavily lower your grade if it's 4 or more. Like I mentioned, AI usage. Last day to withdraw is November 16. If you have a family emergency, if you need an incomplete, you'll have to reach out to me and we'll talk about it. That requires me to petition the dean to give an incomplete. I can't just give it myself. Let's see. And then I have a breakdown of all the modules here. So module 1, we'll start that today. I'll just give you a background of what civil litigation really is and our role in it. And then next week we'll do jurisdiction. And then module 3 is preliminary consideration. So this is all the stages of pretty much litigation till the end is each week. And then the last 2 classes will be solely for presentations. That'll give us 3 hours for presentations. Okay. Keep in mind this is subject to change. Oh, I do realize I don't have a title of the textbook here. So I don't really use a textbook too much just because I don't use every chapter in the textbook that's for this class. I'll put the title on it anyway, just in case some people like owning it. I'll put it in there. I'll put it in the syllabus after class. But I only take certain excerpts from it and I upload the PDF readings for you. So you don't have to worry about buying a book. Or I'll refer you to websites to read something. So you don't have to worry about purchasing a $100 book. A lot of money. And there are more fun ways of learning how to do something. Okay. Let's see what else. Classroom rules. I'm just going to go over this for respect purposes. Look, I'm a really nice person. And if you read my classroom rules, I'm not. I'm not that mean, but I've just seen a lot of great crazy behavior the last 6 years that I've been teaching. A lot of it, most people are more bold on Zoom than in person because I don't really remember seeing any of this in person. Um, Talk to each other with respect, right? If I start to see you guys fight with each other, fight with me, look, I'm not even going to reprimand. I'm not even going to get into it on the screen. I'm just going to look you up on the participants list and remove you. Okay. Just letting you know if you have to be removed for bad behavior, I had to remove you from the roster because more than likely going to make everyone else uncomfortable at the next class. So just letting you know that's my protocol and I'm not changing it. And you could cry to administration, but I will show them the recording. How to submit assignments on Canvas, right? If you're having any Canvas issues, let me know and I'll ask someone in IT to troubleshoot it for you, or maybe it's down. But if you email it to me, I might not see it. So, and I might accidentally give you 0. So make sure it's on Canvas, but if you have a tech issue, let me know. We'll fix it after class. Let's see. If I give you a Google Doc, put your name on it. Some people totally forget to put the Google Doc, their name on the Google Doc, and then I don't know who to give credit to, and I might give you 0. Best way to reach me is on Canvas email. So for submissions on Canvas, cut and paste your text in there or upload a Word doc is fine, PDF, or give me a link to a Google Doc. But please don't password protect it. Chasing after people for password drives me insane. Yeah, no crazy requests. People have asked me, could we not have a final? No, can't request that. As I said, tech, it's fine. You need a computer, office hours. Office hours, look, I'm more than happy to talk to you about your career ambitions, what direction you want to go in, letters of recommendation. If you need help and you don't understand the material, more than happy to give you any specialized attention. Okay? But office hours are not for asking me personal questions or just rambling on about. Keep in mind there's a weight room and there's a lot of people in there. Like I don't want to be rude and cut you off, but it really has to be about business and professional issues. Nothing about schmoozing. More than happy to see your puppy. That's totally fine. But some people could literally talk for the full 2 hours. So I'm gonna have to make that clear that there are other people behind you. I can give out free legal advice, right? You could use any strategy I teach you in class if you're going through some type of legal issue to assist yourself. But again, I'm not an attorney. And even if I was an attorney, right? Attorneys are not experts in every field of law. So can really help in specialized issues, especially if we don't know the context of the whole case file. We said Miss Bernardo, it's fine. Cheryl is fine. Professor, it's fine. Camera time. I understand that people are at home taking care of kids, or you're at work on your lunch break. So, or trying to work while during this class. So I'm okay with camera on, camera off. I respect your privacy. But if I hear crickets, there's no one talking in the chat box and there's no one volunteering at all, I'm going to have to ask people to turn on the cameras. Okay, just so you know, I respect that your privacy, but you have to be active, right? So I know that you're alive and well and you're actually here. Yeah, raise your hand if you have questions. Happy to call on you. I ask people to just raise their hands just because a lot of people unmute themselves at the same time and talk over each other, talk over me. It's chaos, just one at a time. Go ahead, Chanel.
The chat box is currently disabled. Was that intentional?
Oh, here, let me go ahead and fix that. Can you guys type in it now? Perfect. Could you guys all put your first and last name in the chat box as well? So as soon as you log in, even if it's 10 minutes before class and I have the Zoom open already, first and last name in the chat box. If you're a little late, if you came in halfway through class because you had Wi-Fi issues, first and last name in the chat box, even if we're mid-conversation. I normally scroll through the whole thing after class for attendance. That's how I take attendance. For anyone who's new here, I see a handful of names I recognize, but most of you guys are new. Let's see. Yeah, no conspiracy theories, please, in my class. No, if you want to bring information into this class, please make sure your sources are vetted. Either it's a reputable publication or you've researched it on several publications. Yeah, because there's a lot of subjective news outlets out there. So um, I don't want to people putting subjective news in the chat box or mentioning it, and then people start fighting with them. Okay, make sure it's vetted. No discriminatory hate speech. Shockingly, this has happened in my classroom before. So just letting you guys know again, I'm removing you and then have to remove you from the roster because if you bring up any kind of discriminatory speech, that will just make everyone uncomfortable for the rest of the semester, and I'm not having that in my classroom. Grading. Okay. Look, assignments are always subject to change because if we get into a really great conversation in class, I might not get to the in-class assignment, right? So I can't really calculate what is an A or what is a B. Final points will be determined closer to the end of the semester, so you guys know. So I can't really calculate what it is at this point in time. What I'm looking for in assignments. So normally when I give you guys a legal issue, a fact pattern, could be fictitious, could be real, and I ask you to answer like, does the plaintiff have a good chance of winning or not, right? So I'm looking for at least one good law. There are usually a few or several types of laws you could use in your arguments. I'm looking for at least one good citation and an analysis, a legal analysis, right? Your critical thinking skills. If all the elements in the law were met by the defendants, plaintiff has a great chance of winning, right? If they're not all met, you could be honest and say, plaintiff doesn't really have a case. That's what I'm looking for. One good citation and then a quality analysis afterwards. Looks like someone mentioned something about a book in the chat box. Registrar charged $2 for the book, but it sounds like that was an error. You guys were charged for a book? Is that how?
I was just, it was on my registrar bill.
Oh, okay. Let me talk to them about that.
So,
Yeah, 'cause I'll only be giving you a handful of that. Yeah, I actually paid for it. Okay. For students, part of their students' programs acquire the mid-semester report. How do you prefer to receive it? Additionally, will points be roughly calculated from what you can see? Okay, so if you are in a student program that requires mid-semester report, remind me in in my Canvas email box, please. And yeah, we could discuss that privately. I know I got hit for like 700, which I had to argue of the double. Okay, I'm gonna ask them what that extra bill is for because I didn't ask the bookstore to purchase a book for you guys. I normally don't. If I gave you a book, it would be an ebook that's free. So let me write that down. Why are you guys getting billed for a book? Okay, thank you for letting me know. I will have to ask them about that. I mean, I could use the $60 to get you like a subscription for software. It would be better. Um, okay, so let's see I did post the first 6 modules. I try to post as much in advance as possible. So if you guys want to jump ahead, you can. I don't have a textbook reading for every module. I might just explain it in class or give you guys like a quick video to get an understanding of it. And then I'll just have activities in that module. So yeah, don't look for a textbook chapter reading in every single lesson. Okay, I think that's all I have to cover so far. Okay, we go ahead and get started on the lesson. And yes, what is your why? I always ask that because most people on the screen are new, and I just want to know what you're interested in, what you want to learn. If there's any civil lit cases going on, if you want to talk about that, I can always work it into our lesson. Okay, Liz, go ahead. Question.
Hey, oh no, I just wanted to comment on the $60 textbook charge. I'm pretty sure that that's part of like their I don't know what they call it, but it's like an equitable access where they charge you $60 and that covers textbooks for all classes you're taking, but you
Oh,
can't
okay.
opt out of it if you like there's like an opt-out page.
Oh, good to know. Okay. And I'll ask them. I think it could also do it on their end as well if you guys were already charged. You'd probably have to get reimbursed. So thank you. Okay, so let's go ahead and get started on the lesson. We'll see if we have time for it to leave. There it is. Okay, 12:20. Because we have an hour. Go ahead and get started. Oh, and every lecture is recorded and it will be put in the module section. So this one will be put in module 1, right? And then next week will be jurisdiction. That'll be module 2. It's normally underneath the PowerPoint slides. And these slides that I'm using are also up in the orientation section. It's either under module 1, I believe. So you guys know if you could always download them. Okay, go ahead and get started. Okay. So in this class, we will be discussing civil litigation matters, right? And I just wanted to compare the difference between civil litigation and criminal litigation because some people, when they're done this before, get a little confused, right? So civil litigation normally is when a private party like you or I could always file a lawsuit against somebody else, right? With criminal law, you normally have to file a police report and report an incident, and you're hoping that the DA will take the case, right, and file criminal charges against the other person. It's not up to us, unfortunately, but you could always file a civil suit, right? So civil requires private plaintiff versus private defendant, right? Criminal is government versus defendant. So the people of the United States versus, or the people of California versus, that's how you know it's criminal, versus Mitchell versus Mitchell, that's civil. The standard of proof in civil is a lot more lax than criminal, right? Because criminal possibly requires punishment of incarceration, right? The stakes are higher. So the burden of proof is on the prosecutor and they have to prove to the jury, and the jury that the defendant is guilty, and the jury has to be 95% sure that a crime was committed and the defendant did it, right? It's pretty high standard to meet. Actually, it might even be 98%, right? They're never going to be unanimous unless they are really sure. Civil litigation beyond reason of preponderance is normally the standard of proof, and it doesn't have to be unanimous. I think 16 jurors. I think it's majority. I know on the federal level, it has to be federal civil cases, it has to be unanimous, but it doesn't have to be in California. And beyond reason of preponderance is literally 51%, much lower. So the jury has to be 51% sure that a civil incident happened and that the defendant is guilty of it, right? So that's what reason of preponderance means versus beyond reasonable doubt. So preponderance is a lot less, it's easier to prove, right? So you can see someone have a criminal lawsuit filed against them as well as a civil suit, right? If it's for murder, right, they could be found innocent of murder, but in a civil wrongful death case, they could be found guilty of that and have to pay the family of the victim whatever they were sued for, right? Usually a wrongful death case is for millions, right? A human life is worth millions of dollars. Some examples of civil litigation, although civil litigation does encompass pretty much every lawsuit you could possibly think of. If there's ever a criminal case, just know that that defendant can also potentially be sued on the civil level as well, right? The victim can always sue for civil, right? If the prosecutor decides not to bring criminal charges against that defendant, the victim could still file civil suit against them as well. So civil suits pretty much cover everything, right? Anything that has a violation of criminal penal code in California will also have a civil equivalent in the law. Like I said, penal code, there is a code for murder. On the civil litigation side, there will also be a civil code for wrongful death case, right? There's equivalent for everything. Normally in civil law, we are looking for money, right? That's the main thing that the plaintiff wants is money. It could also potentially be for action or inaction, meaning if they want the defendant to let's say they hired the defendant to do a construction job, right? And they didn't finish it in time, right? The lawsuit could be for the defendant to hurry up and finish the job, or why didn't they finish it? Why did they leave the project half done? It could be to get a court order to force them to finish the job, right? Adversely, if there's some kind of action you want the defendant to stop. For example, if they're dangerously building something near a preschool, right? The court judgment might be for them to halt construction until school is out, right? Because those are children. So that could be for action or inaction. And for a civil rights case, it could be for change of policy. If an employer's protocol internally was discriminatory, even though they didn't mean for it to be, they could be sued to change that law or rule within their procedures at that company. So civil is mostly about money, but it could be about change of policy, action or inaction. And policy, yeah, just those things, but mostly you're looking for money. Here's just a list of some of the things you think about in civil litigation, right? Personal injury, tort, that's a big one. Tort is any accidental thing that could happen, which is mostly what happens in civil law, right? Class action lawsuits, right? You normally see those with larger toxic tort cases, right? Crash of a Boeing 707, property disputes, so any damage to property, complaints against the government. So if the government made a mistake, if a state administrative agency or federal agency wronged you in some way and you're looking for money, that's also civil. You normally will sue on all these issues for civil, right? Landlord-tenant issues, unpaid personal loans, business disputes, that's huge in the Silicon Valley, in the Bay Area. Business disputes, breach of contract, intellectual property, medical malpractice, legal malpractice, any type of professional malpractice, every mishap where a party is responsible financially. Civil suits are over use of money, assets, requiring the court to force an action or inaction, pretty much any dispute you could think of in court. Right? And I put an asterisk next to these types of laws at the bottom, probate, family, bankruptcy. Those are also beyond reasonable preponderance. They are also considered civil, but that's not what we're going to be studying in this class. The procedural rules of probate, family, and bankruptcy are totally different from the civil litigation we're going over in this class. I'll show you guys basically what the normal civil litigation process is. Probate, family, and bankruptcy are run differently. They're not necessarily going to have opening statements, presentation of evidence, and closing statements. Those are done differently in front of a judge at the judge's discretion within their courtroom. Political violation like impeachment, also considered civil violation, because even if the president, let's say, was impeached and removed from office, they're not going to go to jail. They're just going to be removed from office. It's a civil matter. However, impeachment is a little different because the evidence presented has to be beyond reasonable doubt, which is funny. So it is civil technically, but the panel of, well, the jury would be the Senate, right? They would have to be 90% sure that the president did some type of political violation and that must be removed from office. Would complaints against the government ever be criminal rather than civil? Trying to think if against the government, there is a special federal courtroom specifically for claims against the government. So that's usually civil. Because if you're suing the government as a whole, right, like I want to sue the city of San Francisco or I want to sue the county of San Mateo, you normally would sue them based on civil matters. I don't believe that you could sue a corporation for criminal and civil matters. Keep in mind, though, that would just be a fine. It would be a fine of $100 million if it was civil. You could up it to $900 million against Walmart or Pfizer, right? If it's criminal, but if the government is an entity, so you would it would be civil. Yeah, believe it would be criminal. You could sue a politician, right? But they would have to be removed from office and then, report them to the local DA or the state attorney, and then we could talk about going after them for criminal matters, right? So it would pretty much be civil against the government. I'm trying to think of the situation. Yeah, I'm pretty sure it's all civil. That would be the US suing itself, wouldn't it? Oh, if we sued the US government or the state government, um, oh, good point, Wendy. If it was criminal, it would be the people of the United States versus the the federal United States government. Yes. Normally, I'm sure you could bring criminal charges against an individual politician, but they would more than likely have to be removed from office. And then the DA or state attorney can go after them. Would it only be considered criminal if the government is on the prosecuting? Oh, yes. Yes. So the people of, yes. So it would have to be the DA, local prosecutor's office, bringing the charges for it to be criminal. State attorney, US attorney would bring a case. So yeah, those three have to be on the prosecuting side of this. Okay, so civil proceedings, right? So claimant sues. So this is the language you would normally use, right? In civil proceedings, we bring a claim against a defendant, right? So it's called a cause of action. Cause of action means like if someone vandalized your home, right, with graffiti or something. Well, that could be a criminal case as well. But let's say you want to just sue the kid, right, to pay for your paint job or whatever. So a claim against that 19-year-old, right, would be a cause of action, right? We would find the law that says vandalism under civil code, and we would bring a cause of action against them, is what it's called, or claim. So that's the language we use in civil. In criminal, it would be an allegation, criminal allegation, a count, how many counts are being brought against that defendant. In criminal law, that would be criminal, right? For civil proceedings, judgment for the claimant if the proceedings are successful. So you get a court judgment in your favor if you're the prevailing party, the plaintiff or the defendant, right? You get a court judgment published in your favor. If you're the plaintiff, you're going to want to hold on to that court judgment so you can use it to collect money from the defendant. It's a verdict. The jury normally reads their decision, and it's called a verdict. And the remedy, like I said, in civil is money, usually money in action or inaction, special performance. It could potentially be sentence, right? Probation or incarceration. Unfortunately, California also still has capital punishment as well, but that's pretty rare. So, and I already mentioned burden of proof. So, criminal procedure, right? We can't file a complaint on our own. All we can do is report it and hope that the local authorities will take it seriously. A plaintiff could file by themselves or hire an attorney to file. Keep in mind, though, well, we're going to learn it in this class, right? In order to have a proper case be filed with, let's say, SF or San Mateo Superior Court, you need to do it correctly, right? So that's why most people would probably choose an attorney. If you want to self-represent, you could self-represent yourself in federal courts, right? It's just that it gets more complicated when you do it yourself. A, when you do it yourself, and B, if it's in federal court, that's also a larger, more complex case, right, than state court. So it's I think there's an interesting question in the Lindsay Clancy criminal case, Massachusetts trial. The Clancys have sued the county for wrongful death because Lindsay wasn't trained for postpartum psychosis, but the same county's prosecuting her, which is a conflict of interest. If the county prevails, it should reduce their debt. The county DA should have recused and let the state file. Oh, actually, I don't know about that case. Regina Clancy, Lindsay Clancy. So the Clancys are suing the county, but the county is also prosecuting her. Oh yeah, I've never seen that before. I'm gonna have to read up on that, but maybe we could definitely get back to that. When we're talking about filing in proper jurisdiction next week. That is interesting. Thank you for bringing that up. I'm gonna write it down. Massachusetts. Yes, because that is a massive conflict of interest. So this is normally what a courtroom looks like. Before, I would always tell students to, if you wanted to pull up a chair, at San Mateo Superior Courthouse, usually they have a calendar and they show what's open to the public. Obviously, you can't see what's closed to the public. Normally, cases are petitioned to be closed if a minor is involved. Otherwise, most should be open to the public for transparency. But nowadays, you could really go on YouTube and watch a full length trial for 2 weeks, right? The Amber Heard Johnny Depp case was pretty interesting. The Kyle Rittenhouse case was on there. I think Derek Chauvin, George Floyd case is all in there. So if you want to see how it actually works in a courtroom, opening statements, presentation of evidence, closing statements, you could just go to YouTube because I know going to the courthouse, you guys all are busy. So normally the witness stand and the judge are up here. The jury box is normally, well, it's not a written rule, but normally the prosecution or the plaintiff sits closer to the jury box because they have the burden of proof on them versus the defense. And then, of course, the public can sit back here to view if it's open to the public. So normally a civil litigation trial process begins with jury selection. So jury selection could happen the morning of, then you choose the jury and the trial starts, right? If it's simple, if it's a more complex case, they might, for example, like the Derek Chauvin, George Floyd case, I remember that they were very meticulous about scrutinizing every juror that was going to sit on that panel. They asked how they felt about Blue Lives Matter, Black Lives Matter, and all these other things. They did a heavy background check on everybody. So it could be days before as well, right? Depends on how serious the case is and how heavily publicized it is, that they need the most unbiased jury possible. And then both sides do their opening statements. Both sides present witnesses and evidence. Of course, they cross-examine. I'm sure you've seen that in movies. And in real cases, televised, right? And then both get to do closing statements, right? And then the judge gives jurors their instructions. And then, of course, they're sequestered. They go over all the evidence that was admitted. They go over, obviously, the judge's instructions. Keep in mind, jurors are lazy people. They could be as young as 18 years old, pulled from school to do this. And they heavily lean on judges' instructions on how to interpret the law. It's especially true in IP law. Stack that deck in favor. And in this class, this is what we'll be going over, right? I'll have you guys go through every stage of the litigation process, right? Trial is like the shortest process in the whole civil litigation process. Informal discovery is when you're on the plaintiff side. So a plaintiff potential plaintiff comes into your office. They give you as much evidence as they have. They give you their statements, and then you, as the paralegal and the attorney, do a background check on everything that they gave you, right? Make sure it checks out, make sure this is a legitimate case, make sure that whatever behavior this potential plaintiff says the defendant did, we can prove it with the evidence that was presented or that we can potentially collect, and that they actually did violate some code in California law, right? That's the one thing that, a defendant could have, been rude to a plaintiff, yelled at them, hurt their feelings, embarrassed them, but unless they broke a code, right, we don't have a case, right? It would have to be something that is actually on the books in the California legislative website or local ordinance in your county. But the pleading stage is when we actually file the civil complaint in the proper courtroom, right? San Mateo, Santa Clara, San Francisco, right? Most 90% of cases are seen on the state level. You might be working on the federal level as well. For example, I worked in IP law and corporate for a long time. So if it is like a larger case, if it is intellectual property, that's all federal. If the case is worth $75,000 or more, you qualify to file in federal if you prefer that jurisdiction. If it's two parties from different states, you could always file in federal court as well. So the pleading stage is when you file it in the proper courtroom and it's accepted by the court, right? They could throw it out if it's not a well-written complaint. They could throw it out if it's the wrong jurisdiction. It has to be done correctly, right? But we'll learn that in this class, how to do that. And then when it's served on the other party, right? A copy of the plaintiff's complaint plus a summons, and you hire a process server to serve the defendant. Now they know someone's suing them and they have the opportunity to respond, right? And to hire their own counsel. So that's all during the pleading stage. 10 days after the defendant is served, the discovery stage starts, which is the longest stage in litigation. It could go years. Honestly, it has gone years with some big cases. It's usually on average 3 to 6 months, depends on how complex the case is. And that's when you do a full-blown investigation. During discovery, you're going to subpoena evidence, you're going to question people, and you're going to also hold a deposition. We'll get to what that is later, but I'm sure you guys have seen some recorded depositions where they interview people on record. And then the pre-trial stage is when we're prepping to actually go to court, right? Your attorney is preparing their legal arguments and you're helping them by going through all the evidence you collected in discovery and organizing it in a digestible manner. So you have a quality presentation to present at trial, right? Then if we actually make it to trial, fantastic. Only 2% of cases in civil law make it to trial. It's 10% in criminal that make it to trial. Everything else is done in alternative dispute resolution, mostly in mediation, right? Because mediation is the most affordable. Basically, there are more expensive forms of arbitration, but 2% make it to trial, right? Unless we go to mediation, which is the most common thing to do, and then you make it to the appeals section if the losing party is not happy with the outcome, right? You can't really appeal though, just because you don't like that you lost. You have to find an error in the trial court's procedure, right? Did the judge give incomplete instructions to the jury? Was there a piece of evidence not admitted that should have been? So you're kind of looking for a mistake that the judge or the jury made in order to file a notice of appeal, right? You can't really just file it because you feel like it. So there are two types of law that are under our code, right? They normally go hand in hand. Substantive law. So substantive law are laws that deal with the content or substance of the law, right? Our obligations. Examples are breach of contract, right? If we sign a contract, we have to adhere to all the terms in that contract. We can't try to get out of it because the defendant, or I'm sorry, the plaintiff might suffer financial damage. We're not allowed to, put our hands on anyone in public or assault and battery, murder, robbery, burglary, all those things. Substantive, right? They kind of control our behavior in public and private, right? It's substantive law. The procedural, it goes hand in hand with that. Procedural means you have to follow a certain set of steps or a timeline. For example, I think for a breach of contract to file in California, I think you have 2 years from the time the contract was broken, right, to file in a civil courtroom. If you don't file it by then, you waive your right to sue altogether, right? So there are timelines for each type of law has its own statute. It's called statute of limitations. So that's normally procedural. Sometimes if you want to sue the government, you have to go through these steps first before you could actually sue in federal court. For example, if you're unhappy with a federal administrative agency, like let's see, well, some agencies, state and federal, have immunity. To be honest, you can't sue the FDA, otherwise everyone would sue the FDA. But there are some you can sue, but you have to file a grievance within those agencies first, right? And each one is different before you could file in an actual federal or state courtroom. So that's normally what procedural is for, to let us know the steps that we're allowed to follow in order to have an actual legitimate lawsuit. Officers can't enter your home, right, without a judge's warrant. They have to go get a warrant signed by a local judge, then bring it to your house, and then they could inspect your house, right? They can't just kick the door down. What would be an example of judge's incomplete instructions? Oh, okay. Incomplete instructions would be, so normally the judge's instructions have all the laws that were discussed at trial, right? All the codes that the defendant potentially broke, how to interpret each and every one of those codes, as well as what pieces of evidence were admitted at trial, right? So it's a in-depth breakdown of all of it and how to interpret the law and what pieces of evidence you're allowed to use, right? So let's say the jury found someone guilty because of some kind of evidence, right? But in the in the judge's instructions, they should have said, oh, well, that was struck from the record. Remember, it was actually inadmissible when they brought it up in court. So if you guys made your decision based on that, clearly it wasn't a proper informed decision, right? I'm trying to think, because I worked in IP in corporate a lot. Unfortunately, with IP law, that's probably the law that requires this like 40-page stack of instructions because it's technology. And an 18-year-old in college who probably doesn't even care about tech, right, is probably all of it's going to go over their head. So those instructions have to be specific, right? All the IP laws, patent laws, the technology broken down to a T, and then all the evidence that can be admitted, as well as how those laws are interpreted. Right. So that's probably like one of the most, when people file a notice of appeal, that's probably one of the biggest ones on there is judge's instructions were incomplete or they weren't clear enough or there was a biased juror. I think those are probably the two most popular notice of appeals. Keep in mind, a lot of appeals are not accepted. A lot of them are thrown out. You just file one hoping that you could overturn the verdict, right? But most court judgments and verdicts are affirmed, unfortunately. So when I talk about substantive law, and when you work in civil litigation, most of the laws that you will be researching and citing and presenting at trial, right, are going to be California legislative statutes. And I'll show you guys the website for that, or local ordinance, right? If you found yourself in traffic court a lot, clearly there are state vehicle codes, but more than likely your city and county will also have its own local ordinances, miles per hour, rules around schools and commercial areas. And if it's a traffic court issue, it'll more than likely be local ordinance and state statute. You'll also use case law, but we'll get to that later. I would say legal statutes, or it's a federal case, federal statutes, right? Anything passed by Congress, signed by the president, or passed by Congress in California, signed by the governor, those are the laws you'll always be using, right? So you guys normally probably hear assembly bill or Senate bills, right? Those are also legal statutes. It's just that they haven't been given a code yet. Actually, let me get to that. Let's go ahead. Right, so this is what I'm looking for when I'm looking for when I'm giving you a fact pattern, and then I'm asking you to look up the law and then give me your analysis on it. Right, so I'm going to want it to be cited correctly. So California statutes normally follow this format here: CAL, CIV, section 450. Right, it could be also, there could also be a subsection like AB, but let me get you guys to bookmark this website. This is the best website. Oh, sorry, this questionnaire. Here's back. We had a case where the judge didn't rule on the core question. So, we appealed. The appellate court order instructed the superior court to just answer the core question. The superior court judge's response to the appellate court was, I declined to answer the core question. The procedure for return to the appellate court was new to us. Oh, yeah, that is interesting. Thank you for sharing, Regina. I mean, it's the lower court's responsibility to answer the question, the legal issue at hand. So I'm surprised that they didn't answer the main legal issue, which is pretty funny. Yeah, that's a great reason to definitely file a notice of appeal. That would definitely be accepted if they're trying to skirt around the legal issue. So I want you guys to bookmark this website. This is one you're going to be using regularly in your career in general. And these are all the California codes, right? So the proper way to cite California code would be CAL dot, and then these capital letters here after it, and then whatever section it is. So if I went into California Civil Code and I was citing section 38, right? So it would be CAL Civ section 38. So that's how you would cite that. Oh, and bills. So you could also look up Assembly bills and Senate bills here. Those are also considered statutory code. It's just that bills were just passed. Like they were just signed by the governor or the president, like literally on the floor, which is why they're you'll probably see them cited as bills first, but eventually they will be given a code to add to that section I just showed you. So Assembly bills, this is how you would cite bills if they haven't been given a statutory code yet. So California Senate Bill 647 or California Assembly Bill 555, right? And on the federal level, this is how codes are done on the federal level. So it would give you like a section, like I don't know what the section is. It could be civil rights, it could be regarding agriculture, right? So that's what this section is for. And then USC stands for US Code, and then this is the section here. The proper way to do it is with a squiggly line, but you could also type out section as well. Either way is fine. Let me show you what bills look like on the federal level as well. Federal level also has HR rep bills and Senate bills. So it would look like this. So HR Bill 332, comma 119th. Off page. There. It would be comma 119th, meaning the 119th Congress, right? And then you put the year afterward. Or Senate Bill 335, right? 119th Congress 2025. If I'm just doing something for my boss, and I would probably just give him HR 332, right? But if we're filing a brief with a courtroom, you're going to want the whole thing, right? You want to be as formal as possible when you're filing something with an actual courtroom or administrative agency. You want to give them the whole thing. It gives them no wiggle room to throw it out, basically is what it is. You want to be as formal as possible. Okay, how can we do the double S on our keyboards, or will we have a specific pro? Oh, thank you, Juliana. I was going to say that there is a shortcut for it. I always hit insert and get it out of symbols and just keep copying it over. But yes, thank you. It's Option plus 6 on a Mac, Alt code for those on PCs. Thank you, guys. Yes, I always have to Google that. And for Constitution, so if you're working on a civil rights case, obviously you'll be citing either the California Constitution or the US Constitution. California Constitution looks like this, right? So it'd be CAL-CON Article 3, Section 2. Or it could be, instead of art, it would say amend, AMEND. And same thing with the US Constitution. The US Constitution Amendment 12 or Article 1, Section 9, Clause 2. So you guys could save a copy of these. Unfortunately, there used to be a free website that gave out these citations for free, but now they charge a subscription. So I'm just going to give them to you guys here in these slides, and you guys feel free to save these. Okay. So that's what I'm looking for when I give you guys an assignment. I'm looking for a proper citation, at least one good one, right? There could be several though, and your arguments would be stronger if you found several of them. For example, if it was a civil rights case, right? If you could find the US Federal Constitution amendment protecting the victim, as well as a California constitutional amendment or article as well, that and obviously the incident took place in California, right? It would just strengthen your arguments to have more than one. Okay, where the plaintiff and defendants were LLCs, the order named individuals in the LLCs with no mention of the LLCs. So unenforceable order named LLCs. Our question was the court to identify it. Oh, the non-party. Yes, you have to be very specific in court judgments as well as all of your filings. If you're suing an LLC or being sued by an LLC, right? Putting the corporation's name in there because you're not suing the CEO, you're suing the company, right? So you want to make sure you put the company's name. You don't care about the CEO unless you're suing the CEO plus the corporation. And you need the proper corporation name. You could look that up on, we'll practice with that. You can look it up on BizFile. You can't just say Walmart, right? You need is it Walmart, comma Inc? Is it Walmart, comma Corporation, right? It has to be the proper name. Otherwise, they could try to get away with, oh, that's not us. Okay, let me go back to my slides. Okay, and I wanted, besides the California Legislative website, I would like you guys to also bookmark federal USC website. So we'll probably be practicing with both federal and civil cases, both federal and state civil cases. Let's see, there's also justia.com. So justia.com is a great, unfortunately, we don't have access to Westlaw. You guys will have access to Westlaw when you take Legal 250, which is legal research and writing. But we can look up free case law here, right? Case law is basically when there was a case that preceded your client's case, identical or almost identical to the case that you have at hand. And let's say you're representing the plaintiff prevailed in that case, you could use it as an argument in your submissions to the court. And of course, at trial, you could always cite that case if it's identical to yours. And hey, they prevailed. So you have a pretty good chance of winning it. Normally, the courts try to follow precedent, right? Or stare decisis. It's basically a previous case that's just like yours. And if a California court ordered that the plaintiff won, the plaintiff should always prevail. And ECFR, this is administrative law. So ECFR are basically federal laws that are created by administrative agencies. So those could also be used in your arguments as well, especially if it has to do with like financial crimes, right? You could look up the tax code in there. If it's a toxic tort case, right? If someone was poisoning drinking water in California or it was a federal law case, right? We could look up the Environmental Protection Agency's violations on toxins by businesses on the federal level. And there's also California regulations as well. As federal law, the federal government has their own federal administrative agencies, right? The IRS is federal. The California Franchise Tax Board is state, right? So California has its own Environmental Protection Agency, as well as on the federal level, there's one too. And the regulations usually follow what the larger federal agency also has, but they make it a little bit more strict or they add on to it in California as well. So that's the Code of Regulations in California. And we'll go over those laws. I'm not going to give you guys executive orders because those are not usually used in lawsuits unless your law firm is suing because the executive order is unconstitutional, right? But usually you're not going to use those. Your strongest arguments are going to be state law, federal law under U.S. codes, California legislative codes, Senate bills, Assembly bills, those, and local ordinance. But every city and county is different, right? Ordinance is different in San Mateo than it is in San Jose. And they all cite it differently as well. So we'll practice with that. Local ordinance could be used a lot when it comes to traffic violations or property vandalism, right? That's when you'll use local ordinance as well. So those are the main types of laws you'll be using. Yeah, and I wanted to go over, oops. Primary and secondary sources. So all the websites I just gave you are primary sources, right? If you could find state code, bills, ordinance, administrative law, right? You're going to lead with those in all of your arguments because they're binding, right? They're binding. The defendant cannot break those rules at all. No one could break those rules. So those laws are current and updated because I gave you guys the government website, right? I always go off the government website because if it's a private website, it's probably not up to date. I love Cornell's website. Cornell Law School has a fantastic website that mirrors everything on the government page, but it's not always updated. So if it's on the government website, it should be the most updated. Secondary sources are not binding law. We use them to help guide us, right? So if you worked for the public defender's office, because the public defender unfortunately cannot choose their cases, they take whatever case is thrown on their desk, right? And they might not be an expert at that type of law. So when you're faced with that type of issue, right? If you work for the Bay Area Legal Aid, if you work for the public defender's office and you and your attorney are not experts in that kind of law, right? You're going to lean on secondary sources. So secondary sources are publications written by judges, attorneys, people with PhDs in that specific type of law, and they give commentary on it, right? They will list codes, ordinance, administrative law, right, in these legal journals and treatises and subjective sources, and they will give you an analysis on that type of law, especially since, you know, if you and your boss are not experts on it, they will guide you, but you can't cite a treatises in, well, I guess you can, but it would have to be low priority in terms, you'd have to start with state code first, state administrative law first, and then you could support it with a treatises, right? But secondary sources are really only used for our research purposes only, not for really claiming in your legal arguments at trial. You're definitely not going to cite the treatises when your boss will, when you're talking, when he or she is presenting, right, their evidence. They're not going to use the treatises. You might cite one in a trial brief submitted to a courtroom, but like I said, it would be the last, at the very bottom, and it would just be persuasive to support the binding mandatory laws, which I just showed you guys, right? State code, all those things. Would case law be considered a secondary? So case law is also used in your arguments. It's ranked higher than a treatise, a secondary source. So case law can be binding if the incident happened in California and we led with state code first, right? And we just wanted, you know, to list more laws to support our arguments. You could use case law as long as it was case law in California. It's case law in Nevada. It's a secondary source. It's primary and binding if it's in California. Would case law be considered? So case law in California is a primary source. And there are, I think, 6. So there are the lower superior courts in California, but we're going to go over this more next week. So SF Superior Court, San Mateo Superior Court, those are the bottom tier trial courts, right? That's where a case starts in those trial courts. Then in California has the mid-level appellate courts, right? Final notice of appeal. You could appeal. You don't have to appeal to the California Supreme Court. You could appeal to one of the 6 districts of mid-level appellate judges. So those are panels of 3. And then there's the California Supreme Court. Just so you guys know, when the California Supreme Court creates case law and the mid-level appellate courts create case law, all of it is binding in California. I know that they separated to 6 districts, but I think San Bruno is in either the first, I think we're in the first district. If there's binding law, case law in like the second, we could use that in our arguments. So all 6 would count toward every case in California. A little different on the federal level. We are in the 9th district, mid-level appellate court, right? So you have the federal trial district courts on the lowest level, mid-level appellate court on the federal level. We're in District 9. We share District 9 with like the Pacific Northwest and Hawaii. And we're in the ninth. Binding case law is only binding in the ninth. We can't use second district, first district. You can, but it's only secondary source. So I just wanted to make that confirmation just so you guys don't get confused. Well, we'll go over it again. And oh, Aaron, what is the reasoning for that? I'm not too sure. I was surprised by that too. I thought we're in the first, San Bruno, right? So if you worked on a case in the first, I can only search case law in the first. But yeah, my superiors told me that actually I could use anything in California. That's a California state law. And then the separation of it, federal law is different. I always had to remind myself of that. Yeah, California could be our jurisdiction, laws in California could be different from the federal. Okay, so the pleading stage, right? So I said the first stage of litigation is the pleading stage. That's when we officially file a civil complaint in court. The defendant is served, and now they know someone is suing them, right? This is the shortest and first stage. A defendant is always hoping they could get the case thrown out at this stage, right? Hopefully they filed it, the plaintiff filed in the wrong jurisdiction. Hopefully they didn't meet the statute of limitations, right? It breached, or hopefully they could file some kind of a request to have the case, thrown out, right? And which is called a motion, basically. This stage probably lasts, I think, could last a month or so. And the pleading stage, 10 days after the defendant is served, right? The discovery stage starts. And we're probably going to spend the bulk of our time on the discovery stage because you guys are going to learn how to draft interrogatories, requests for admissions, requests for production of documents, and depositions. So this is why it takes 6 months or so, or years, to do all 4 of these stages. Interrogatories are questions to the other party. And in civil litigation, they are mandated to answer it, right? Obviously, criminal law, you're not going to serve a defendant interrogatories. They have the right to remain silent and don't have to help you. But in civil litigation, both parties are allowed to ask each other questions, right? As long as it's relevant to the case. Requests for admissions are same, but they're not open-ended questions. They're usually yes or no questions, admit or deny questions. Requests for production of documents. 3 will probably take you the most, right? That's when you have to be really an investigative analyst for number 3, because you would probably have to get your boss to sign subpoenas, right? You probably have to go try to get Ring 4 camera footage or security camera footage from people not even attached to the case. You're going to have to hunt down witnesses if they're willing to talk. You're going to have to get copies of police reports or whatever else you can find, right? So 3 is normally the bulk of your investigation. And then 4 is normally when you invite the defendant, or if you're the defendant, the plaintiff, to sit for a recorded deposition or questioning. That by the time you get to that stage, you're at the end of discovery already. You're at the end of discovery. As a paralegal, you're going to be an expert on the case, and your boss is going to heavily lean on you for that. And you're going to help with the questioning on camera, right? Because the questioning on camera is important. If the other party says something on camera and they're changing their story on the stand at court, your boss can absolutely call them out on that, right? But 1, 2, and 3 is normally leading up to preparing for the deposition. Yes, what's confusing about the document requests, as I was preparing for the deposition, are deadlines, and we'll definitely go over all of those. Yeah, there could be, demo could get delayed. You have to make sure that every witness you want to be there is at the deposition, that you subpoenaed them, that you subpoenaed any documentation you want there, because normally you only want to do it once. it depends. If deposition could be affordable if you're here, if you work on the federal level, if you work in IP law, you probably would have to travel to hold that deposition, and that can be pricey for your clients. Why do people not get tried for perjury? Well, you can report them for, well, every pleading you submit with the courtroom, right? Plaintiff complaint, defendant's answer is under penalty of perjury. Every interrogatory, every question the other party answers, and we answer every request, every yes or no question. It's all done under penalty of perjury. So is questions during deposition. You can report to the local DA's office that they lied on this interrogatory or they lied during the deposition. But does the DA have, the capacity to go after all those people in every single incident? Unfortunately, no. You can definitely report it, but I'll be honest, like they do have bigger, more expensive cases, and if it was innocuous and it didn't change the outcome of the verdict or the court judgment at the end, normally they let it go. I'm not saying go ahead, lie on these documents. It's very risky. You might be the one example they make of you, because they have punished some people, but then it's rare and in between, I would say. I do remember seeing a case where an attorney actually brought in a fake witness, right? I think under deposition, and he actually went to jail for like 20 years, but that was definitely an outlier for sure. I guess a more refined thought there would be, why is perjury not enforced more stringently? I agree with you, Aaron. I think it should be. I think there should be like $1,000, like a fine, maybe a very scary fine, like a $5,000 or $10,000 fine for perjury every time they commit perjury. So they would be more careful with their answers, but the system isn't perfect. And a lot of times we'll go over some examples. You'll notice too when they return requests for admissions as well as interrogatories, sometimes they're vague, and that's technically not perjury, but you can tell that they're trying to skirt around accountability. Okay. So oh, during mediation or after the trial commences, the judge. Okay, so I also wanted to go over alternative dispute resolution, which we'll be talking about in this class too, because like I said, 98% of cases will end before they get to trial, because the discovery process is very expensive, right? We're billing to our client $400 per hour as a paralegal. Attorneys probably $1,000 per hour, sometimes 1,500 per hour for interrogatories, requests for admissions, depositions. So a lot of that is why people concede and go to alternative dispute resolution instead. So normally, most cases go here, right? We go negotiation, mediation, arbitration. Mediation or arbitration are more successful because you hire a third party to help you come up with a resolution, right? Arbitration can be binding. So it's one of the best types of alternative resolution. It ends here. Normally, an arbiter or an evaluator is normally a part-time judge or lawyer, right? Or retired judge as well. Mediator could actually be a paralegal, right? A mediator really is just someone who took a mediation course, 40-hour mediation course. And I could actually give you guys a link to that if you guys were ever interested in doing the 40-hour course. Normally, mediation is not binding, but it allows for more flexibility to be more amicable until you come up with a resolution. So you kind of sit at a table, or sometimes I've seen it done in two separate conference rooms, and the mediator walks back and forth until we come up to resolution that day, because we're hoping we don't come back after that day, right? And a mediator, like I said, is cheaper because they charge less because they're not an attorney or a judge. They normally are a normal person. I do think, though, that parties would trust an experienced paralegal more as their mediator than just a random person, right? If you worked in personal injury for 5 years, maybe that would be what your specialty would be, or family law, that would be where especially they would trust you more because you know the law better. Negotiation is the cheapest, but there's no third party, so that normally ends up back in court. Keep in mind, unless alternative dispute resolution is ordered by a judge, if it's just recommended or the parties decide to do it voluntarily and you still can't agree, you might still end up back at trial. If the case could go back to trial. That can definitely happen. Okay, guess that was my last slide for the day. I know I threw a lot at you guys on day one. Does anyone have any questions? No? Okay. I think we have time for an activity. Fantastic. Okay. It's up on Canvas. I published it under module 1. It says in class, substantive, and procedural law. And I basically just want you guys to find the proper California legal citation in this case regarding false imprisonment. And if you could find the statute of limitations for that case.
I think you
I would
need,
always start with, okay.
sorry, I'm not seeing it on my end for module 1. I tried refreshing Canvas.
Let me refresh mine. It should be under module 1, litigation and the paralegal.
Yep, just popped up.
I know I
Solid.
separated orientation. Okay. I'll give you guys maybe 5 to 8 minutes to find those two things. We'll stop maybe 5 minutes before so we can talk about it. And my best advice would be to do a general search first, see what you could find, and then of course look it up on the California Legislative website to make sure it's correct. I'll let you guys go from there. And I'll pop back in at about 1:24 or so. Everyone see it okay? Oh, go ahead, Marilla.
Same with my classmates, professor. I cannot see it even though I try refreshing the canvas.
Okay, let me just cut and paste it into the chat box.
Okay, that works. Thank you.
For you guys. So I gave you a scenario, and then just want you guys to find the code regarding that type of the statute of limitations. Oh, and I do have to remind you to find the civil code, right, versus the penal code, because this is a civil case. We're almost at time. And actually, I was doing the search with you guys. Does someone want to give the citation that they found? I know it's not, it might be under California during Casey during instructions. Is that what people found? If you want to put your citation, if I'm rushing you too, like that's, you can finish this for homework and talk about it next week.
Yeah, Calvin 236.
I'm sorry? Does anyone want more time? Because we have 3 minutes. We can finish it for next week if you guys feel rushed. Could you guys give me a yes or no in the chat box if you want to talk about it next week? We only have 3 more minutes. Okay, so keep in mind. Okay, so I realize it's only officially under California Penal Code. So if we're suing for it on the civil level, we would actually be looking. Actually, you know what? I'll put the hints in the prompts and I'll let you guys figure it out. Yeah, Judith actually found it. Yeah, so sometimes if it's under civil, because I'm sure you guys found under penal code, no problem, right? But it looks like we don't have an official California civil equivalent here, unless you guys are able to find under procedural law or, okay, Regina found it, okay. Or California, here, let me give you guys a link for it too. It could be a little tricky. It could also be under California jury instructions. Which you could also use as a citation. Let me go ahead and find that. Link to it in here as well. Just you guys could look into those and yeah, finish your answer. We'll talk about it next week because I only have 2 more minutes. Does anyone else have any questions? Otherwise, I'll give you guys another homework assignment in addition to this, and then we'll start again next week. So next week, we're going to be talking about jurisdiction and the whole tiered court system I was just talking about on the federal and on the state level. So next week, we will talk about jurisdiction. Yeah, so you can go ahead and read everything in those modules, as well as the chapter reading for today as well. Don't worry, I'd expect you guys to read anything for today. And we'll finish sharing our answers next week. I realize maybe we were on a time crunch and this one was actually tricky. Yes, put your answers up on Canvas. Please, that's how I know you guys did it. Oh, good point, Wendy. I just thought it was odd. She considered false imprisonment. She stayed in her car, right? Just because she wants to sue for something, right, doesn't necessarily mean she has a great case. And that's how we will determine that by looking at the law itself. But we'll talk about that next week. And then we'll start jurisdiction. So you guys are free to go. It's 1:29. If anyone else needs an ad code or had problems with their ad code, feel free to stay after. Office hours are Friday if you have any questions. Otherwise, enjoy the rest of your afternoon. It's still early. Thank you, guys. Oh, let's have some DMs. Answers on Canvas. Sorry, I always miss the direct messages. For some reason, semester. Okay, thank you, Jennifer, for letting me know. Harry needs a code. Okay. Let me go ahead and get that for you, Harry. Oh, so we'll discuss. Is he still here? If All right, let me just get Harry ad code and then I can answer questions. Okay. Here, I just direct message you an ad code. Oh, go ahead, Olivia.
I
Oh,
was
wait,
just
hold on.
curious.
Let me.
Oh, sorry.